Okay, good day. I will be speaking today on data protection and privacy management. My name is Akinwale Akindia. All right. This is a topic that is becoming more relevant as the days go by, uh, not just in Nigeria, but globally. All right. So the EU, all right, actually uh, brought data protection and privacy to uh, as a front burner discussion point with the GDPR. All right, even though we've had a Californian law on privacy, which is also globally recognized as a force to be reckoned with, right? Uh, in the area of data protection and privacy. Okay, Nigeria also, I think in 2019, came up with NDPR, right? Our own data protection regulation, championed by NIGDA at the time, right? Until 2023, when we actually had a proper law, an act of Parliament on data privacy. All right, that is the NDPA, all right, Nigerian Data Protection Act of 2023. All right, so this is a very important topic, all right, especially for compliance professional, risk managers, GRC guys in organizations across the whole world, all right? Compliance risk is becoming very, 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 very material globally. Fines and penalty. You can just go to Google, all right, or go to a generative AI and just check, right? Uh, GDPR fines, right? Fines and penalties. I think there's a particular website on that, right? And what to have there as penalties is just right. It's becoming very, very significant, very, very material. All right. So let's just jump into the course. Let's start with definitions. So what is data protection? People even often you know interchange the definition of data protection and data privacy. They are similar, right? But they are not the same. They're similar, but they are not the same. So data protection is the practice of safeguarding sensitive information from data loss and corruption. All right. So you need physical security, you need cyber security. All right. You need information security to ensure data protection. So basically, so that's the CIA, right? The CIA triad, the confidentiality aspect, all right? Confidentiality, integrity, availability of information. That's what data protection is all about. All right. So the goal of data protection is to protect data and ensure it's available and there's compliance with regulatory requirements. So data protection, is leaning more towards security, right? Now let's talk about data privacy. All right. So how do you feel if you open a bank account and one day you just open Facebook or one of the social media apps, and you see your cash, your bank balance, actual bank balance on social media, all right, your picture, your email, official phone number, all right, and so many other personal information, your credit card details, your debit card details, primary account number, even your PIN, all right, details on your card, CVV2 and the rest of it, you see them, all right, among, all right, some other victims of data breaches on social media. How do you feel? How will you feel in such a situation? Now, that is a breach of your privacy. All right, it means the bank has not been able to uh, ensure that you are in control and you have a sense of being in control over your personal data. So data privacy is the process of ensuring individuals have control over how their data is collected, used, stored, and shared. So it's my data, it's my personal data. So I should have control. I should be able to tell you, okay, I'm giving you this information because you have a legitimate basis or a legitimate interest. All right, you have a legal basis to collect the information. But I'm giving you this information on this condition one, two, three. All right. So as long as you don't exceed one, two, three conditions, all right, then we're good. But the moment, for example, all right, you didn't tell me you're going to share my personal information with marketers, and after sharing it, after giving you my information, I started receiving calls, all right, which could have only come from, all right, people you have shared my information with. That is what we mean by data privacy. So the data privacy is about ensuring, uh, data subjects maintain controls and also have a sense of control over how their data is collected, used, stored, and shared. Great. Now, so what is personal data? Personal data means any information relating to an identified or identifiable natural person called data subject. All right. So an information that is, we can use to actually identify an individual. All right. For example, all right, your name, all right. An ID, maybe staff ID or a matric ID, your location data, all right. So that's very sensitive, right? But there are so many apps you are using today that they want to know where you are. They want to know the exact point. And in fact, some of them will not work very well anyway. That's knowing where you are. For example, you want to, book a ride online. All right. So we have to be very have a sense of assurance that the information is properly managed. All right. An online identifier, all right, like your user ID, right, your username online, all right. So, or informations that relate to your physical, physiological, genetic, mental, economic, cultural, social identity. So basically, personal data is data which either individually or in aggregation can be used to identify, a data subject. All right, so we have controller processor. So if you look at GDPR, for example, all right, NDPR, most of these laws, so you'll be seeing the term controller processor. So who is a controller? What's a controller? So the controller means the natural legal person, public authority, agency, or other body which alone or jointly with others determines the purposes and means of the processing of personal data. So basically, a controller is the organization, all right, that collects and determine the type of information, personal information to be collected. That's the controller. All right, they may do the collection and the processing through a processor. So the judgment call of who to collect information from, what to collect, all right, is not from the processor, it's from the controller. That's how you know the difference. So the processor is more or less like an agent of the controller, right? So a processor means a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller, right? So in terms of hierarchy of responsibility and accountability, all right, yes, there could be joint responsibility, but accountability goes to the controller. All right. Then consent. What's consent? Consent of the data subject means any freely given, underline the word freely given, specific, informed, and unambiguous education of the data subject wishes by which he or she, right, by a statement or by clear affirmative action, signifies agreement to the processing of personal data related to him or her. So consent must be freely given. Yes, I'm giving you permission. I'm giving you go ahead to use this data in this forms or for this purpose. All right. Look at the keywords. All right. It must be freely given. all right, it must be specific, right? Like for example, they say you can't bundle, you can't bundle concepts, you cannot bundle multiple purposes and say, okay, just bundle this, right? This we use your data for this, for this, for this, for this. Could you just sign up at once? No. All right, it has to be specific, all right. It has to be unambiguous. For example, now you can't. Most of the data privacy laws or data protection laws do not agree that you should pre-check consent, a consent box. For example, so you are not allowed to pre-fill a consent box. I say, okay, if you do not agree, uncheck, kindly uncheck this. No, leave it blank. Let the data subject be the one to make the decision whether to check or not. All right, so still talking of definition. So personal data is broadly categorized into general personal data and sensitive personal data. So this is very important, right? For you to know what kind of data are you collecting in your organization, what kind of data are you managing in your organization. So sensitive personal data is also known as special categories of personal data. Now, if fines are going to be dropping, maybe from the EU or from the Nigeria Data, the Protection Commission, for example. All right, they will also look at the kind of data, personal data involved, and that will also affect the kind of penalties that that organization that have broken the law might suffer. All right, so you have general personal data. So example, identification data, your name, your address, your phone number, your email address, or any other information that can be used to identify an individual. That's identification data. Number two, you have communication data. Your phone number, for example, phone numbers are unique, right, to you. All right, email addresses, any other communication methods. All right, demographic data. So your nationality, all right, citizenship, date of birth, and other demographic information. All right. So these are general personal data. All right, then now we have sensitive personal data. These are special categories of data which if the organization is, collecting or managing any of this information, all right, you've got to be very, very careful. You've got to be very, very careful. So number one, data relating to race or ethnic origin. All right, data relating to race or ethnic origin. Why? All right, is it regarded as sensitive personal data? We've had cases of ethnic cleansing, all right, in the history of the world. Unfortunately, all right, people who have been, killed sometime because of the race they belong to or the tribe they came from, all right. So there are case studies all over the place. No, I don't want to be mentioning case studies because of the sensitive nature of the discussion. But you see, look at the history of the world in the last 2,000 years. So there have been cases like that. So you want to be able to manage such information very carefully, all right, so that it doesn't get all right exposed without the authorization of the data subject. All right, political opinion also. People have got into all manner of trouble, especially highly placed people, all right, in organizations, in public sector, all right, for sometimes personal opinion or personal opinion made on political issues, all right, maybe made in private, all right, getting leaked, all right, for example, so it becomes problematic. Maybe the person made a call discussing with a friend or an associate, all right, and sometimes those information gets to the public one way or the other, and it could be very embarrassing. All right, so you want to manage those kind of information based on the agreement with the data subjects. All right, religious or philosophical beliefs, of course. So that is very personal. Your religious conviction is very personal. So you need to be able to. So if you are collecting data about religious beliefs of data subjects, you have to be extra careful in managing that information. Trade union membership, all right? So in my career, I've seen people getting sacked, all right, for membership of, all right, of a union. all right, or unions or union members becoming too, what would I say now, too emphatic, too pressing, all right, uh, in their quest for maybe their members to have better deals. So sometimes it could become the membership of a trade union, all right, may become, a platform, or a way that can open up uh, uh, possibility of persecutions, all right? It can lead to persecutions, all right, uh, from states, from state authorities, from corporate leaders in the organization, and so on. All right. So if you are managing information about trade union membership, you want to be very careful. Then, of course, genetic data. All right. DNA analysis result is sensitive. All right, sensitive personal data is classified as special categories of data. We can see what DNA is being used for, all right, especially in solving crimes, all right, murders of 30 years ago, all right, crimes done 40, 50 years ago have been solved, all right, with DNA. So that kind of information, you don't want to play with it. Biometric data, of course, fingerprint, facial recognition, all right, voice pattern, iris, retina, all right, and so on. So biometric data is also classified as special category. Data concerning health, all right, especially for hospitals, HR or human resources often have departments often have this information for all staffs, medical history, sickness records, medical diagnosis, genetic predispositions to diseases. You want to be very careful how you manage those information. Then lastly, data concerning a person's sex life and sexual orientation. All right. So if for the nature of the business you do, you collect such information, you want to be very careful how it is managed. All right. So to my wonderful audience outside there, so these are the sensitive personal data, special categories of data, which you are required to be very, very careful about. All right, so let's talk about GDPR, General Data Protection Regulation. All right, so GDPR is an EU law that is binding on all countries within the EU, all right, all the states within the EU. So the General Data Protection Regulation was first published on April 14, 2016, but it came into effect on May 25, 2018. So the GDPR has 99 articles and 173 reciters. All right. Now, in realities, the articles are actually the law. All right. The articles are the law. The reciters are meant to offer guidance. All right. On how to implement the articles, how to, comply with the articles. So it's just like ISO, right? So you have ISO 7001, for example, as the requirement standard. You have ISO 27002, ISO 27003, all right, ISO 27004, ISO 27005, all right, as guideline standards to help with the implementation of ISO 27001 again. So that's exactly the way it is. So the reciters help you to be able to understand how to implement the articles. So the articles are binding on the member states in the EU, while the reciters are not binding, basically giving you more information on how to meet the requirements of the articles. All right, so this is how it is. The GDPR is structured into 11 chapters. All right, and you can see the breakdown of the articles. Chapter 1, Article 1 to 4 is general provisions. All right, chapter 2, all right, is principles. Chapter 3 is the right of the data subject. Chapter 4 is controller and processor. Chapter 5 is transfer personal data to third countries or international organizations. Chapter 6 is independent supervisory authorities. All right, Chapter 7 is cooperation and consistency. Chapter 8 is remedies, liabilities, and penalties. Chapter 9 is provisions relating to specific processing situations. Chapter 10 is delegated acts and implementing acts. Chapter 11 is final provisions. All right, so this is how GDPR is structured. All right, 99 articles, 11 chapters. Okay, so GDPR lays down rules relating to the protection of natural persons with regard to the processing of personal data and rules relating to the free movement of personal data. All right. So the idea behind GDPR is that personal data should be able to move freely, all right, within the EU, but in a secure manner, right? In a secure manner. So GDPR protects fundamental rights and freedoms of natural persons, and in particular, their right to the protection of personal data. Now, United Nations established clearly that, all right, when it comes to data privacy and data protection is enshrined in in the concept of human rights. So we cannot be talking of human rights without talking about, all right, data protection, personal data protection, and privacy. All right, so that is basically what Article 1 is saying. Basically, all right, reinforcing the idea that, personal data protection and privacy is a fundamental human right. That is what Article 1 says. All right, Article 2, all right, talks about the processing of personal data. So it's talking about GDP applies to the processing of personal data only or partly by automated means, and to the processing other than by automated means of personal data, which form part of the filing system or are intended to form part of the filing system. All right, what does that mean in simple grammar? All right, so once you are processing personal data in your organization, either using automated means, all right, computerization, or manual means. All right, that's what that means, or maybe hybrid. All right, GDPR applies to you. GDPR does not apply to the processing of personal data by a natural person in the course of a purely personal or household activities. All right, so you're just in your house. All right, personal data process. All right, basically for personal purpose. All right, it's not within the scope of GDPR. All right, GDPR does not apply to the processing of personal data by competent authorities for the purposes of the prevention, investigation, detection, or prosecution of criminal offenses, or the execution of criminal penalties, including the safeguarding against and the prevention of threats to public security. Now, that is the security principle globally. All right, national security overrides, all right, your data protection and privacy concern. All right, of course, people may argue it, so people may say no, all right, it's not correct, it's not invading on my privacy, but generally, all right. So your privacy should not hold a nation, the whole nation, all right, to to suspense or to hold them to ransom. That is basically what that is saying. And I think most individuals will agree, all right, that it's better that that maybe there is a little bit, all right, an extent of information, all right, personal information being obtained, especially when it's not abused, all right, when it's not abused. All right, so for example, in America, you have, I think the Patriot Act, all right, which was passed after 9/11. All right, so that is a clear, demonstration of these principles. All right, so if the government or the police or the security organizations are investigating something that has to do with public security, national security, all right, then in that case, GDPR may be suspended. All right, it might not be, it might be a bitter pill, but that is the reality. All right. So GDPR applies to the processing of personal data in the context of the activities of an establishment of a controller or a processor in the union, regardless of whether the processing takes place in the EU or not. And that is very interesting, right? For you to take note. So because you are outside EU does not mean that GDPR does not apply to you. That's what they are saying. So whether you are in the EU or you are not in the EU, GDPR may apply to you. So it's very important that you need to look at this law very well. All right, it's a law, but it's an EU law, EU regulation. All right, so you need to be able to look at this regulation very well to know, all right, how it might affect you. even if you're outside the European Union. So GDPR applies to the processing of personal data of data subjects who are in the Union by a controller or processor not established in the Union, where the processing activities are related to, all right, offering of goods or services, irrespective of whether payment of data subject is required to such data subject in the Union. All right. So if you are offering goods or services to somebody residents in the EU, residents in the EU, even if you as an organization is not within the EU. That's what that Article 3 is saying. GDPR applies to you. All right. If you are processing personal data of data subjects resident in the EU, all right, in such a way that you are monitoring their behavior, all right, as far as their behavior takes place within the region. So, for example, your website you use cookies, all right, and your website is maybe your website is hosted maybe in United States or maybe in Canada or maybe in Asia or Africa, and those your sites are being browsed by people in the EU, all right, and you have cookies, and so definitely GDPR will apply to you. All right. Uh, GDPR applies to the processing of personal data by a controller not established in the Union, but in a place where member state law applies by virtue of public international law. All right. So maybe your country has like a charter that have been, co-signed with with the EU. That automatically, GDPR may apply to you. The use of a language or a currency generally used in one or more member states. So what are the currencies that are used, all right? So for example, you have the euro, right? You have the euro as the principal currency in the EU. So if in your website you are selling goods and we can see, all right, apart from maybe naira, dollar, all right, you're also selling, there are options to sell in euros automatically. You know that GDPR is applicable to you. All right, or the language you are using. So, for example, I'm speaking English. All right, so I know that maybe somebody somewhere in France, somebody somewhere, all right, in uh, Finland or in Sweden, Norway might actually come across this video. All right. So once the language is basically what is being spoken, all right. For example, though I know there are some countries in the EU that have their own language, all right, like for example, the German language, all right, the Swedish, all right, language, and so if you are using all those languages to conduct businesses, you automatically expect EU people resident in the EU to deal with you one way or the other. So you have to be very careful to check the TPR, all right, out. That's Article 3. All right, so scenarios where GDPR will apply. All right, a Nigerian company website is intentionally targeting EU users. All right, or whichever country you are. All right, USA, Canada, Japan, China. All right, South Korea, North Korea. All right, for example, you're offering prices in euros. All right, you're marketing in EU languages, you're shipping to EU, and automatically GDPR will apply to you. All right, or a Nigerian company or any company based outside the EU tracks behavior of people within the EU via cookies, analytics, or profiling. All right, so you have international organizations, for example, like Visa, MasterCard, all right. Basically, it's known that they actually they track user behavior, all right, on your credit card, on your debit card, all right, for security reasons. They want to know your normal profile so that the day there's going to be transaction outside the normal profile, they can secure it. All right, so it's perfectly legal. But in that case, all right, since they are tracking the behavior of people in the EU, all right, automatically, all right, GDPR is applicable to them. So these are scenarios. So let's look at key GDPR requirements. All right, organizations handling personal data must ensure lawful basis for processing. So what that means is that data processing must be on consent. The data subject must have given his or her consent. All right, it must be based on contracts, it must be based on legal obligation or other legitimate grounds. So we're saying you must have legitimate grounds for collecting information. All right. I remember some time ago I went to an eatery. I wanted to buy what now? Was it ice cream? Yeah, I wanted to buy ice cream. So I was asking. So the attendant, the salesperson was asking me, okay, which flavor, this and that. All right, so I was answering the questions. Then the next question is, okay, your phone number. All right, so she was keying in all my information that I was given to the system. Then she was asking for my phone number. I said, for what? Why do you need my phone number? Because I want to buy ice cream. All right. And she could not defend it. She could just say, management said. No, you don't tell me management said now. All right. It's my personal information you want to collect. All right. So what is the basis? What is, of course, I'm also talking from my knowledge, all right, in data protection and privacy. So what is the legitimate basis for asking for my phone number because I want to buy ice cream? She could not defend it. So I politely refused. So you need to ensure lawful basis for processing. You need to implement security measures. Like I said, that protection aspect, you need cyber security, you need information security. All right. So if you have implemented 27,001, all right, or you are considering it, it will also actually be a bonus. You need to appoint a data protection officer, DPO. All right, that is also very important. You have somebody in the organization that is going to be in charge of data protection. They need to report data breaches, all right, once they occur based on the provision of the regulation. All right. So fines and penalties under GDPR. This is very interesting. So if a business violates, or even an individual, all right, even individuals can run into trouble. So if there is violation of Article 8, 11, 25 to 39, 41 to 43, oh, you are looking at 10 million euros or up to 2% of the total worldwide annual turnover of the preceding financial year. Whichever one is higher, that is what EU will go for. All right. So they will look at your, audited financial statement for the previous year. All right. Globally. All right. Charlie, which is multinational globally, not just one country. All right. Globally, 2%. All right. And if that is not up to 10 million euros, they might go for 10 million euros. All right. The violation of Articles 5, 6, 7, 9, 12 to 22, 44 to 49, and 58. All right. You're looking at 20 million euros as fines, or up to 4% of the total worldwide turnover of the preceding financial year. Whichever one is higher, that is what they go for. So you don't want to make any mistakes or any missteps that will lead to the violations of these articles, especially the uh, the latter one, which has more higher penalties. All right, so that is that about GDPR. So just a bit of overview of GDPR. Uh, if you have more questions on GDPR, you can always reach out to me, or you need a course, all right, you need a training for yourself or your team on GDPR, you can always reach out to me. So let me come on to Nigeria. All right, so in Nigeria too, we have Nigeria Data Protection Regulation, all right, which was actually created in 2019 by NIDA, National Information Technology Development Agency. All right, NIDA has really done a lot for Nigeria when it comes to information technology and digital transformation in Nigeria. All right, they've done a lot, creating frameworks, creating roadmaps and strategy for the country in the area of IT and cyber security. So they took the first big leap for Nigeria by creating these NDPR right in 2019. All right, but you know, the legal bite wasn't that strong, all right, because it was more or less like, you know, a regulation, all right, not really a law. Like in the EU, no, in the EU, when you have a regulation, the regulation is more or less like a law, binding on all the states in the EU. But you know, so but in Nigeria, the until 2023, all right, they now passed it into an act of parliament. So you know the way the legal framework is, all right, you really need for adoption, nationwide adoption. You need that parliamentary bite, and that's what was done in 2023 by creating the replacing the NDPR with the NDPA, Nigeria Data Protection Act 2023. All right. So the NDPA provides a legal framework for the protection of personal information and establishes the Nigeria Data Protection Commission. They've been doing wonderfully, all right, in the area of bringing data protection to as a hot topic, all right, for discussion in Nigeria like it has not been before. All right, so NDPC is there, all right, for the regulation of the processing of personal information. All right, so structure of the NDPA 2023, just like we did for the NDPR. So this time around, so we have part one, objectives and application, data sections 1 to 3. Part two, establishment of the Nigerian Data Protection Commission and its governing council, section 4 to 13. Part three, appointment of the National Commissioner and other staff of the Commission, sections 14 to 18. Part four is financial provisions, how the Commission will be funded, all right, section 19 to 23. All right, part five is principles and lawful basis governing processing of personal data. So that's sections 24 to 33. All right, part six is rights of the data subjects. That's sections 34 to 38. Part seven is on data security. That's section 39 to 40. Part eight is cross-border transfer of personal data. That's section 41 to 43. All right. Part 9, registration and fees. That's sections 44 to 45. Part 10 is on enforcement. That's sections 46 to 53. Part 11 is on legal proceedings. That's sections 54 to 59. And lastly, all right, part 12 is on miscellaneous provisions. That's section 60 to 66. So there are 66 sections in the Nigeria Data Protection Act of 2023. So if you look at many materials, many discussions, NDPR is still coming up. People are still talking NDPR, NDPR. All right. So you need to get that out of your consciousness, especially when in Nigeria or you're doing business, all right, with Nigerians. NDPR is rested, as in rested and retired. So NDPA is in charge now when it comes to the legal framework on data protection in Nigeria. All right, so let's talk about NDPA requirements. NDPA shall apply where data controller or data processor is domiciled in, resident in, or operating in Nigeria. All right, so if the company, the data processor, the data controller is in Nigeria, NDPA is applicable. All right, if processing of personal data also occur within Nigeria, NDPA is applicable. Then if the data controller or the data processor is not domiciled in Nigeria, just like in the GDPR, right? It's all right, it's not domiciled in, it's not resident in, operating in Nigeria, but it's processing personal data of data subject in Nigeria, then NDPA is applicable. So wherever you are in the world, outside Nigeria, as long as you are dealing with all right, personal data of people residents in Nigeria, then NDPA is applicable. Okay, the Act established the Nigeria Data Protection Commission. That is section 4 of section 1. All right, so the NDPC is now the regulatory body. All right, before NIDA was doing that, but with the passing of this Act, all right, the NDPC take charge, all right, directly. So the commission shall be a body corporate with perpetual succession and common seal. It may sue or be sued in its corporate name. So if the NDPC takes a decision and you not agree, you can go to court. All right. The commission may acquire, hold, and dispose of his property. All right. The commission shall have his head office in FCT. Now, FCT, Federal Capital Territory in Nigeria, is Abuja. All right. And the commission may maintain other offices in any part of Nigeria for the purposes of achieving the objects of the commission. So even though the head office is in Abuja, they are allowed to have, all right, regional office or territorial offices all over the country. The Commission shall regulate the deployment of technological and organizational measures to enhance personal data protection. All right, I believe they've been doing that, so you see a lot organizing seminars, and basically their auditors have also been going around, all right, and they also have means of collecting, concerns from the general public, organizations that have violated data subject rights, one way or the other. So the Commission shall foster the development of personal data protection technologies in accordance with recognized national best practices and applicable international law, where necessary. All right, accredit, license, and register suitable persons to provide data protection compliance services. They're also doing very well in that area. I can confirm that. All right, so they do training for data protection officers regularly. All right, and they are also responsible for accrediting DPCO, right? The Data Protection Compliance Organization, who are basically accredited consultants in the field of data protection and privacy. So the Commission shall register data controllers and data processors of major importance. They also shall promote awareness on the application of data controllers and data processors under this act. And the Commission shall promote public awareness and understanding of personal data protection rights and obligations imposed under this act and the risks to personal data. They are doing wonderfully well in that area also. All right, consent under NDPA. This is addressed by Section 26. A data controller shall bear the burden of proof for establishing a data subject consent. So you're on your own. That's what you're saying. So you just have to, if you're collecting people's personal data, you better be guided. You better be convinced. You better be persuaded that you have a legal basis for collecting that. All right, because the law is going to scrutinize your legal basis. All right, look at this. Silence or inactivity of the data subject shall not constitute consent. The general belief is that consent, consent means yes. That's what we're told growing up, right? But now this law is saying the fact that a customer or a data subject did not complain, all right, does not mean he or she is in agreement. So where the processing of personal data is based on the consent of the data subject, the data subject shall be informed of the rights to withdraw consent prior to the granting of consent. So consent is not perpetual. Consent is not permanent. All right. So I can give you my consent in the morning and withdraw it in the evening. All right. That is what this law is saying. The withdrawal of consent shall not affect the lawfulness of data processing that occur before the withdrawal of the consent. So a customer gave you consent, all right, to use his or personal data. 3 months after the consent was withdrawn, you are still accountable as a data controller for everything you have done under that consent, all right? So before the consent was withdrawn, a request for consent shall be in clear, simple language and very accessible. So you have to be very careful the way you design your consent form, either manual or electronic. All right. Consent shall be in the affirmative and not based on pre-selected confirmation. I'm talking about that. So you don't pre-check the box, say I agree, and you have already, all right, fill the box for the user. No, uncheck it. Let the user data subject be the one to check it himself or herself. Consent may be provided in writing, orally, or through electronic means. All right. So that is a little bit overview of NDPA. Of course, we cannot look at the entire NDPA, all right, in this presentation. This is just meant to provide an overview, so you can reach out to me if you need, more detailed training on Nigeria Data Protection Act, the GDPR. But there's also something we need to look at, all right, before closing this discussion on NDPA. So there was an implementation tool or document that was created, all right, to help for people that want to implement NDPA, all right, because it could be very confusing. Some of those things, all right, if you are not a professional in that field, it might just be difficult to interpret. It's law, of course. Law is technical anyway, word. So to simplify it, all right, the what is called General Application and Implementation Directive (GAID) was created. So GAID is basically like an implementer tool, all right, for implementing NDPA in Nigeria. So it was created by Nigeria Data Protection Commission. So it is meant to clarify, remove all doubts, all right, so that you can be able to really know how to implement NDPA. So it is just very clear. All right, who is affected by NDPA? Who each organization is under the purview of NDPA. You see it there. What you need to do, you see, is there engaged. So let's talk about principles of data processing. All right, it's very related to what you see in GDPR. Number one principle: lawfulness, fairness, and transparency. So personal data shall be processed, collected lawfully. They have a legal basis. All right, you have to be fair and you have to be transparent to the data subject on how and why you are collecting the information and what you will do with it. So it must be very lawful, it must be fair, it must be transparent. No hidden, no hidden motive. Number two, purpose limitation. What you told the data subject you are collecting the personal data for is exactly what you should do with it. All right. That is purpose limitation. Do with the information you are collecting what you told the data subject. Anything outside that, all right, you have broken, all right, the law. Okay. Number three is data minimization. Collect just about enough personal data to get your job done or to get your business objective achieved. Don't collect more information than you need. That's data minimization. It's different from, all right, purpose limitation. Purpose limitation is why. All right, why are you collecting this information? Limit the use of personal data to the why. All right, data minimization is talking about like the amount of data, quantity of data. So if you don't need, all right, the date of birth, for example, why will you collect it? All right, if you don't need the biometric data of a customer, why will you collect it? All right. So number four is accuracy. All right. Personal data shall be accurate and where necessary, kept up to date. All right. So as you're collecting the information, these are personal information. You don't want to misspell people's name. You don't want to make a mistake in somebody's date of birth. We've had so many cases like that of celebrities. I don't want to be mentioning names, but I have quite a list of, especially in sports, all right, people that their names were changed, all right, through, mistakes made during processing, all right, and they have to stick with that, name that was created through a mistake. There are so many people like that, all right, in so many phases of life endeavors that systems change their names, systems change, all right, their date of birth, and so on. So you want to make sure that information is collected, is stored, all right, as accurately as possible. Okay. Uh, Number five is storage limitation. So this is also very important principle. All right. So you want when you have collected the information, once the purpose of collecting the information, all right, as elapsed, delete the information securely. Dispose that information, securely. That's what storage limitation is saying. All right. The data is needed, all right, from January 2025 to December 2025. This is January 2026. That data should be out of the environment. should be out of your system. All right, that's storage limitation. The number six, integrity and confidentiality. So this is where cybersecurity is now applicable. All right. So data protection. We want to ensure the integrity of the data. We want to ensure the confidentiality of the data. So you are looking at things like encryption, all right, data loss prevention tool, anonymization, all right, access controls, and so on and so forth. All right. Tools, SIM tools, security information, event management tools, all right, file integrity monitors, and so on. So all the technology, you could deploy all the standards we could deploy to ensure integrity and confidentiality. We want to see them playing out here. All right. The last one is accountability. All right. So the controller shall be responsible for and be able to demonstrate compliance with the six principles above. So you are responsible, you are accountable as a controller for any personal information you are collecting, and you must be ready to to dance to the music, whatever happens. All right. If there is a fallout, all right, in the way you manage those personal information. Ladies and gentlemen, these are the seven principles of data processing, all right, which you should be aware of, whether you are ensuring compliance with NDPA or GDPR or any other privacy or data protection law globally. All right, so we've said that personal data must be collected lawfully. All right, lawfully. So how do you know that the information you are collecting, you have a lawful basis, all right, the legal basis for it? So number one, all right, basis for lawful processing, the data subject has given you consent. All right, we said it. Consent can be verbal, can be written, can be electronic, all right, but the consent is not assumed, all right. So the data subject has given you consent, you are good to go. Number two, there's a contract, all right, between the data subject and the data controller. All right. If there's a contract, there's no way you will establish contract without submitting personal information. Even between two companies, all right, you will need details of the directors, right? So personal information of leaders in both parties, all right, will be required. So contract is provide a lawful basis for collecting and managing personal data. All right, there is also legal obligation, right, to collect those information. So there are some organizations, right, by law, they must collect some information from you. For example, the bank, all right. So you go to a bank now to make a cash deposit, all right, maybe cash deposit of up to $10,000, all right, and above. Some personal information must be collected, all right, which are established by law. All right, so that is basic. So you can't tell the bank, why are you asking me for this information? They have a legal obligation which has been established by law to collect that information from you, all right, for reporting to FIU or any other body that may be relevant. So that's legal obligation, all right. Then there's vital interest. Vital interest means they are doing this for your own good, all right. So you don't even need to give them consent, direct consent. So, for example, somebody, all right, there is an accident, for example, all right, and the person needs blood transfusion, all right. So, whoever is attending to that, victim, accident victim, obviously, for the good of the victim, they can search. They want to know the blood group, for example. All right. So they might want to maybe check through the cards, identification card on the victim to know whether they can get things like blood group. You don't need, even you as an individual, you don't want to you don't want to question them for that. You don't want to say it's a violation of your privacy. You're trying to save your life. So that is vital interest. All right. Then the other one is public interest. If it is in the interest of the public to collect that information, all right, then they have to look at what happened during COVID-19. All right, look at the COVID-19 lockdown and the pandemic. So some information were required, all right, personal information. You can't say no, all right, because it's in the public interest, all right, national interest to collect that information, all right. Then the last one is a legitimate interest. If the company can establish that they cannot do their business or their operation, all right, especially on behalf of that customer without collecting those information. All right. So legitimate interest. All right. So you want to do bank transfer. All right. There, there's some information you will willingly submit. All right. For you to be able to do that transfer. You want to open an account. All right. So it's in the legitimate interest of the bank to collect your home address, all right? Maybe office address if possible. All right. They want to know your age, they want to know your phone number, they want to know your occupation. All right. Those information is they need those information to collect. All right, to open your account. So they have a legitimate interest, they can prove it. So these are areas, all right, these are ways you can prove that you have a legal basis for collecting and managing personal information. All right. So it could be consent, it could be contract, it could be legal obligation, it could be vital interest, it could be public interest, and it could be legitimate interest. All right, so let's talk about rights of data subjects. Like when we establish in GDPR Article 1 that data protection and privacy is enshrined in human rights. It is basically your right as a human being to enjoy data protection, to enjoy data privacy. So number one, right of access by the data subject. I've submitted my personal data to you. I have the right to come and check once in a while, all right, the status of my data or ask for certain uh, um, aspect of my personal data to be extracted for me, all right? Then number two, right to rectification. So if I made a mistake, all right, like I gave example, even the system, the process can make a mistake, all right? So maybe after I've submitted my name, I notice that my name has been altered, all right? Maybe they made a mistake in processing. I have a right to go back and say that is not my name, all right? They made a mistake, or I make a mistake, or I maybe in the age of birth, all right? I have a right to go back, all right? And say, okay, this is correct, all right? Maybe I need to swear that bit, or I need to bring my original date of birth and things like that. So I have a right to rectification. All right. You have a right to rectification of personal data. Number three is right to erasure, right to be forgotten. So I willingly gave you my consent. I am now willingly withdrawing the consent. And I'm telling you, I have no business with this organization again. Remove my personal information. So you have that right to erasure, right to be forgotten. Number four, right to restriction of processing, right to restriction of processing. So you have a right to determine how your data is going to be processed. All right. You have the right to decide how your data is going to be processed. You have the right to determine, all right, uh, where you don't want your data to, the kind of technologies you don't want to for them to use to process your data. All right. So you have that right to restrict processing, all right, of your data in what either a manual form or automated form. All right. The next one, notification, obligation regarding rectification or erasure of personal data or restriction of processing. So restriction of processing, all right, can also be looked at in the way of like, okay, stop, stop processing. All right. So I have a right to say, okay, for the next 1 month, the next 1 year, I don't want any transaction on my account. All right. I can block, for example, in banking, you can block your account, right? You can send a message. You don't need any reason to tell them, just block this account. All right. Block the account. All right. Uh, I'm not expecting any transaction for the next 3 months. Just block my account. So that's also an example of restriction of processing. Now, if, for example, they restrict your account or your personal detail in any way, they should notify you. All right. Like for example, I had an experience recently. I got to the bank. I think I wanted to do a transaction. Then I noticed that the teller was telling me that you cannot process, that the account is blocked. I was surprised. Why? Why would my account be blocked? I should go and see the customer service. I went to the customer service. The customer service officer was telling me that they are that's somebody's email, all right, someone no that I was getting, all right, that that somebody's email was mapped to my account. I said, look, how was that my business? Am I the one that created the account? Am I the one that set up the account? I gave him my official email. All right. So if we made a mistake in mapping somebody's email to my account, just delete it now. Just remove it. That's not my business. That's not my mistake. All right. And again, all right. And I let them know, okay, you blocked my account because of this. Something that is a mistake from your side. They, you are blocking my account. You didn't even notify me until I go to the banking or and I want to do a transaction. All right. That's when I'm discovering that my account was blocked. Now, that is not best banking practice. All right. And honestly, I gave them a piece of my mind on that day to make them know that what they have done is against the law. It's against the right of it. Say, if you are blocking my account, I should know why you are blocking my account. All right. So there is a notification obligation on the part of the data custodian. All right. If there's a rectification is being made or a change is being made, all right, at their end about the personal data data subject, they have a right to data portability. I have a right to say you can change it custodians. So you will move my data from custodian A to custodian B. All right. The next one is right to object. All right. So the data subject have a right to say no, all right, to certain transactions, to certain activities. All right, for example, I can say, no, I don't want my personal data to be used for marketing purposes. I have a right to that. So I have a right to object to that. All right. Then rights to automated individual decision making, including profiling. What does that mean? So a user have the right to say, look, you cannot do processing of my any decision concerning me and concerning my personal data 100% through automated means. What is the implication of that? Look at AI, for example. Somebody wants to apply for a loan in a bank, all right? Then the bank has an AI tool, all right? They just feed in the account, maybe the statement of account of the person, filling maybe the credit score and some other things. And the AI decide and say, don't give this loan. And just on that, the bank decided not to give it. Now, that is it. If you have read the EU Act, which if you have not, I will encourage you to check. If you have read the EU Act and most ethical um, guidance on artificial intelligence, the general rule is that you should not, all right, use AI decision, hook, line, and sinker. There must be human intervention because AI can make mistakes. Even symptoms, for example, there is what they call a false flag, right? You have false flag, you have false positive. So it will take human intervention to know a false flag. So the same way, all right, look at also in insurance, all right? Somebody is making a claim after paying insurance for 10, 15 years. There's something happened, the guy is filing a claim, all right? And then the insurance company decide to use an AI tool, all right, to decide whether that claim should be paid or not. And the AI2 says, all right, don't pay. And they didn't subject that decision into human review. All right, is not ethical, basically. All right, and that is what this particular right is emphasizing. So a data subject has the right to say no. Any decision you're going, key decisions you're going to make about me or about something that concerns me, don't use 100% automated processing. All right, there must be human interventions or human review. All right, so these are the rights of the data subjects, and they are very critical to NDPA, to GDPR, or any law on data privacy and protection. So I've talked about data controller. That is the organization or the set of legal entity that makes a decision, all right, data to collect, how to collect it, for whom to collect it, all right. In Nigeria, so this is from GAID now. So a data controller or data processor shall be deemed to have particular value or significance to the economy, society, or security of Nigeria, and hence designated to be of major importance if it keeps or has access to a filing system, whether analog, manual, or digital, for the processing of personal data and processes the personal data of more than 200 data subjects in 6 months. So if your organization, so this is how you know whether the law, if you are a company or organization in Nigeria, this is how you will know it's applicable to you. All right. If you are processing the personal data of more than 200 data subjects in 6 months, automatically, all right, you are under the umbrella of NDPA. All right. Or carries out commercial information communication technology, ICT services, or any digital service, any digital device which has storage capacity for personal data and belongs to another individual. Or processes personal data as an organization or a service provider in any one of the following sectors. So what that is saying, what he's saying is that it doesn't matter whether you go up to 200, all right? Yeah, whether you process personal data of more than 200 or up to 200 or not. If you are in these sectors, automatically NDPA applies as applicable. If you are in aviation, you are in communication, you are in education, you are in electric power, you are in export and import, you are in financial, you are in health, you are in hospitality, you are in insurance, you are in oil and gas, you are in tourism, you are in e-commerce, you are in public service. Automatically, all right? All these organizations are directly under NDPA. The NDPA is applicable to them. Whether they do one or they do two or they do 200, it's applicable. So the law actually specifically listed out, all right, this uh, organization in this sector. Now, also, now looking the GAID also divided the controllers into 3 levels, all right? So you have the ultra high level, you have the extra high level, you have the ordinary high level. So you need to now know which one does the organization fall into. Let's look at it. Ultra high level. Ultra high level shall be a category of data controllers and data processors of major importance that are among other obligations generally expected to abide by global and highest attainable standard of data protection, taking into account the following factors for ultra high level. All right, sensitivity of personal data in their care. Don't forget, we said there are 2 categories of data the other time when we are starting out. All right, data-driven financial assets entrusted in their care by data subjects. All right, reliance on third-party servers or cloud computing services for the purpose of substantial processing of personal data. So once you are relying on third-party servers or cloud, you know that your risk is higher, all right, because you don't have total control, all right? Substantial involvement in cross-border data flows, all right? Processing the personal data of over 5,000 data subjects. So that's the keyword. That's if you are processing the personal data of 5,000 data subjects in Nigeria, all right, within a year, all right, automatically you are classified as ultra high level. All right. The need for international standard certification for people, processes, and technologies involved in data confidentiality, integrity, and availability. So, if especially your organization is processing up to over the personal data of over 5,000 data subjects, all right, then you are categorized as ultra high level. So, provided always that any four of the foregoing factors above shall suffice for the purpose of the categorization. So, if you meet 4 out of these 6 items, all right, we have attributes listed here, automatically you are ultra high level. 4, just 4 out of 6. All right, so that's ultra high level. Then we have extra high level. So your organization might be under extra high level. So this shall be a category of data controllers and data processors of major importance that are among other obligations generally expected to abide by global best practices of data protection, taking into account A, sensitivity of personal data in their care, data-driven financial assets entrusted in their care by data subjects, functions as an establishment of government, reliance on third-party servers. All right, so you can see it's very uh, uh, close to the ultra high. So reliance on third-party servers or cloud computing services for the purpose of substantial processing of personal data, substantial involvement in cross-border data flows. Then F, look at that F, processing the personal data of over 1,000. So if organization is processing over the personal data of over 1,000 data subjects, all right, then you are extra high level. All right. G, the need for reputable and standardized certification for people, process, and technologies involved in data confidentiality, integrity, and availability. Now, so the same way, if you meet four, all right, if you meet four of any of these requirements, automatically your organization is qualified as extra high level. All right. Then lastly, we have ordinary high level. All right. Ordinary high level. So these are also, so you can see the attributes also. If you meet for sensitivity of data assets in your care, inherent vulnerability of data subjects, they typically engage with, maybe by virtue of the kind of data you collect. All right. For example, now, any organization that is collecting data about debit cards, all right, those people, the data subject are at your mercy, all right. Primary account number, CVV2, all right, expiry date of cards. And those individuals are basically their financial life, all right, is at stake, all right. Because we've seen cases of people going to, all right, supermarket, going to petrol station, all right, gas stations, use cards, and before you know it, somebody that is in US, all right, they are using, his or her card in another continent. So these things are there, all right. So high risk to the privacy of data subject if such personal data are processed by the data controller or data processor in a systematic or automated manner. D, processing the personal data of over 200. You can see the quantitative metric now. Ordinary and level 200, over 200 data subjects through the means of technology, under technical control, through a service contract. The need for adequate technical and organizational measures for data protection. Then F, the need for reputable and standardized certifications for people, processes, and technologies involved in data confidentiality, integrity, and availability. All right. So, like we said, once you meet minimum of four of these criteria, then we are listed as ordinary high level. All right, so data processor, we talked about that. Data processor is the organization that processes the personal data on behalf, all right, of the data controller. All right. The NDPA also talk about the role of the data protection officer. All right. So the DPO, all right, must be somebody with expert knowledge of data protection law and practices and the ability to carry out the tasks prescribed under this act and subsidiary legislation made under it. So the DPO may be an employee, all right, or maybe an outsourced professional. So the law gave the rights either to use a member of your staff or to use a contractor for that. So let's look at the roles of the DPA, the DPO. The DPO shall advise the data controller or the data processor and the employees who carry out processing made under this act. B, monitor compliance with this act and related policies of data controller. Or data processor, and also act as a contact point for the Commission on issues relating to data processing. All right. The data controller or data processor shall ensure that the DPO does not carry out his or her task under duress, coercion, overt influence. So you cannot intimidate the DPO. He or she shall not be dismissed or penalized by the data controller or the data processor for performing his or her task. The DPO shall directly report to management. So that independence is very important. All right. So you expect the DPO to have a direct access to the CEO, to have a direct access to the board. All right. Data subjects may contact the DPO with regard to all issues relating to the processing of their personal data, which means what that is saying is that the contact details of the DPO should be publicly available, especially in your privacy policy. All right. So the NDPA also established the NDPC, all right, the National Data Protection Commission, which is a statutory Nigerian organization responsible for the regulation of data privacy in Nigeria. The commission is responsible for enforcing data protection laws and ensuring compliance with data protection standards in Nigeria. NDPC aims to safeguard the privacy rights of individuals and promote responsible data management practices across various sectors. All right, so they are actually Uh, they are a new, relatively new organization. All right, they're a relatively new organization, just starting it. The law was passed in 2023, and believe you me, they are really moving, taking giant strides in deepening data protection and privacy in Nigeria. All right, so I will round up with these data privacy impact assessment. All right, it's enshrined in NDPA. It's also enshrined in GDPR also. All right, it's basically risk assessment. All right, data privacy impact assessment is essentially risk assessment on data. The vulnerabilities of the organization based on the kind of data you manage, collect based on the kind of processes you run, based on the kind of products and services you run, all right, you offer. All right. So where are the areas where you can be exposed, all right, or where data breaches can occur? That is, what are the consequences? What are the likely consequences? All right, fines and penalty, loss of customers, all right, loss of reputation, all right, financial implication, revenue loss, and so on. Then you start coming up with the uh, mitigants, all right, or mitigating factors, all right, that you are going to use to manage, all right, the risks you have identified. So data privacy impact assessment, or DPI, is basically risk assessment that is done, all right, by an organization to determine how what are the likely data privacy exposures, all right, that they may have, and how those risks are going to be managed. All right, so that's about this course. My name is Akinwale. So I believe you have learned one or two things, all right, on this course. If you have more questions, you can always reach out, all right, to me. I will answer your questions. Thank you so much.